Okay, well, I'm sure we'll have a few more people joining. Hello, my name is Ben Rhodes. I'm the Senior Vice President with CAMS. Today we have Hunter Cornelius with us to lead us through leashes, laws, and living together with animals and community associations. So as a reminder, we do record these sessions and they will be located on the camsmgt.com website under the board member resources page. So hope you will visit that and share this information with your friend. We do take questions throughout the presentation. And so tonight we're going to try and have a hard stops at 5:30. So if you do have questions, please get them in early so we can get those answered for you. We're going to try and do this presentation in two parts. So we'll have a first half talking of specific animals. And I think, Hunter, you said FHA. We're going to get into some FHA information. So please feel free to type those questions in. People, parking, and pets are probably the three most common things that we deal with in community associations. And so a very timely topic for the pets portion of what we do. So Hunter, I will turn it over to you and let you get started.
Thank you. Good afternoon, everyone. Like Ben said, my name's Hunter Cornelius. I'm an attorney at Ward & Smith. I'm located in Raleigh, North Carolina, in our office here. We have 5 North Carolina offices, Raleigh, Wilmington, New Bern, Greenville, and Asheville. And as of earlier this week, we now also have a South Carolina office in Columbia. We have a new partner down there, and as well as about 10 attorneys licensed in South Carolina. So I know we've got a mix of North Carolina and South Carolina folks on this call, and our firm can service clients in both states. Okay, get moving. Okay, so like Ben said, we're going to talk about animals and community associations. We're going to start with talking about pets or beasts, as they're referred to sometimes in this presentation. And we're going to go through what is a pet, talk about how you determine that under your declaration, what if your declaration doesn't specifically define pets, etc. And then after that portion, we're going to move on to assistance animals. And then maybe can answer a question or two about wild animals if you have them. Not as much detailed on that aspect, because wild animals tend to be a case-by-case basis, and as they come in, and they're pretty specific to the type of animal. Like if you have a stream that runs through and beavers that are damming that stream, it's going to be a little different than dealing with hawks that come in and pick up a chihuahua off the street. Real fact pattern that has happened there. First, household pets. Big question to start is, what is a household pet? Well, that's going to, in part, depend on your declaration and whether a pet or a household pet is defined in your governing documents. And if it is, then we're going to go with that definition. And we're going to have to evaluate each animal based on the specific definition given in your governing documents. But what if there is not a clear definition in your association's governing documents, or it's silent on pets? If that's the case, then North Carolina and South Carolina law similarly both apply the general rule that if in a contract, which your restrictive covenants are considered a contract, if there is an unambiguous term that's not defined, you're going to give it its normal, ordinary meaning. In other words, you're going to go to the dictionary and you're going to pull up household, you're going to pull up pet, you're going to put those two together to figure out what exactly is a household pet. So now you can get more restrictive than that, like we mentioned, and that's in a definition in your declaration, and when you do that, you can limit the type of animal that is considered a pet. For example, your definition can limit pets to cats and dogs. Or you can say a pet is cats, dogs, chickens, and snakes if you want those 4 items in your declaration. You can also limit the number of pets that an owner may keep on the property, the size of the pet. Maybe dogs are permitted under 100 pounds, the type of breed, anything that you can specify in that definition gives you greater ability to enforce the definition. The clearer you are, the easier it is to rely on that. Now, oftentimes declarations give boards and homeowner associations the authority to promulgate rules and regulations. Generally, we would not recommend using your rules and regulations to define a pet. If you're going to give a restrictive definition of a pet, particularly limiting the number, size, breed, and types of pets, you want that in your declaration because that's going to have the greatest weight and the greatest authority. Additionally, your rules and regulations, we frequently see they only apply to the common area unless your declaration specifically says rules and regulations apply to lots as well. If you include your pet restriction in your rules and regulations and it only applies to the common area, it's not going to be helpful if you're trying to tell someone they can't have a certain type of animal fenced in their yard, fenced in their home. For example, if you put a definition in your rules and regulations that say alligators are not pets, but there's no similar provision in your declaration, well, you have no basis to tell someone to not keep their alligator in their yard unless there's some sort of town ordinance or whatnot that prohibits that. So a couple examples of community associations that have attempted to implement more restrictive definitions of pets in their governing documents. We're going to roll through those just for y'all to see how this comes into play when you've got a restriction and what does pets mean. All three of the cases I'm going to talk about are from North Carolina, but like I said at the beginning, the general principles here also apply to South Carolina. I did a review of South Carolina case law and did not readily find a South Carolina case that addresses or a pet restriction in a homeowner association covenants. But like I said, the general contract interpretation principles in South Carolina are the same as in North Carolina. So it's reasonable to expect that in a similar circumstance in South Carolina, we'll get similar outcomes to these cases. So this first case, Steiner versus Windrow Estates. This is a case where a homeowner association had a restriction in their covenants. This is Windrow Estates, just for some background, is an equestrian community. So they allow horses, but they also had a pets restriction that prohibited livestock, poultry, and it created an exception from that prohibition for horses, dogs, cats, and other pets. And that other pets language is what's going to be operative here. So the Steiners are a family that lived in Windrow Estates, and they decided they wanted to have some Nigerian dwarf goats. You can see some cute pictures of that type of goat on our slide here. They're goats. The wife and the couple of the Steiners was unfortunately diagnosed with cancer, and they did some research and found that Nigerian dwarf goats can be good therapeutic animals for people with the type of condition that Miss Steiner had. So they went out and got 2 Nigerian dwarf goats. The goats were neutered and had their horns removed before they got them. In other words, they did not have the ability to reproduce. They did not have the ability to produce milk. And because they're Nigerian dwarf goats, there's no market for their type of meat in the United States. So what that means is these 2 goats had no commercial value. They were raised solely as pets. They had names, and the Steiners named their goats Fred and Barney. They interacted with their goats much like owners do with dogs. The goats were affectionate and gentle with their owners. The Steiners would walk the goats on leashes. Goats would come up and sit in their laps. They used dog carriers to transport them to the vet. They even wore sweaters when it got cold. And the goats learned how to play fetch as well. So what happened here was like I said, the Steiners got the goats. The HOA found out about the goats and said, hey, there's no livestock under our declaration. Livestock's prohibited. So you're going to have to get rid of the goats. And the Steiners For obvious reasons, they didn't want to get rid of their goats. The goats had become part of their family. They were part of the support system, so they pushed back. I'm not sure why they didn't push back on them being emotional support animals, but they said, no, these goats are pets. They are not livestock. They argued about it, and it eventually went to the Court of Appeals. And the Court of Appeals, in that interpretation, they latched on to what I pointed out earlier, is that in that definition or that restriction that said no animals, livestock or poultry of any kind shall be raised, bred, or kept on any lot except horses, dogs, cats, or other pets. They said, well, this exception has other pets. Pets, what is and is not a pet is not defined in your declaration. So the Court of Appeals looked to the Merriam-Webster's dictionary to determine the ordinary meaning of pet. They determined a pet was a domesticated animal kept for pleasure rather than utility. And in this case, they applied those facts that I gave you, walking on a leash, playing fetch, having names, and determined that Fred and Barney were in fact pets, even though the declaration purported to prohibit livestock, which you would think a goat would often be considered livestock, Fred and Barney in this case were considered pets. So this is a good example of the importance of having, if you are going to have a restriction that defines pets and restricts pets, you want to have a well-drafted restriction, because this one was loose enough that even though the prohibition on livestock was there, these goats were allowed to stay. So in contrast, we're going to look over here at Schroeder versus Oak Grove Farms. And I've got a Court of Appeals citation on here, but this case was recently heard in front of the Supreme Court, so I'm going to talk about that outcome here. A very similar circumstance in Schroeder, where there was a restriction that prohibited anyone from having pets as they're defined in the Union County Ordinance. And then there was also a livestock restriction that prohibited animals, livestock, or poultry of any kind to be raised, bred, or kept on a lot except dogs, cats, or other household pets. So important there. There's that or other household pets language again. Now, in the facts of Schreiner, so the Court of Appeals, again, Shriners have these chickens. In this case, there are 60 chickens. They're fancy chickens. I don't know what that exactly means, but there's some type of breed that was categorized as fancy chickens. Allegedly, every chicken had a name. The Schroeders cared for their medical needs. They bathed the chickens. They spent 1.5 to 2 hours a day with each chicken. So the Schroeders and their crafty lawyer said, hey, we know about that Steiner case. Just like those goats in Steiner were pets, so are our chickens. So when the association tries to tell them they have to get rid of the chickens and start fining them, the Schroeders push back, goes to court, goes to trial. The trial court finds that these chickens, unlike in Steiner, are not pets. So the case gets appealed up to the Court of Appeals, and the Court of Appeals applies that exact same analysis that we just talked about with Steiner. And they said, hey, the Schroeders, they know the chickens' names. They bathe them. They care for them. These chickens are clearly pets, and even though there's a prohibition on livestock, there's an exception from that prohibition for dogs, cats, and other pets. So when we apply the standard definition of pets, these specific chickens are constituted a pet. Now that wasn't the end of the story for the Schroeders, because the Schroeders then pushed back again and they appealed it up to the Supreme Court. And just a month and a half ago, I think the Supreme Court ruled on this case and found that they disagreed with the Court of Appeals. They looked at the number of chickens and said, hey, 60 chickens, 60 pets, that's a lot for anyone to keep up with. They also looked at the owners claim that they spent 1.5 to 2 hours a day with the chickens. And if you divide that by 60 chickens, it's about 2 minutes per day with each chicken. So how much of an emotional bond and a pet bond can you have with only 2 minutes each day with the chickens? They also looked at the testimony from the trial court, and the owners, the Schroeders, while allegedly every chicken had names, they weren't able to recall the names of all the chickens or what exactly how many chickens they had. And they only knew that they approximately had 60 chickens. Uh, so so the Supreme Court took all of that and said, hey, while we agree with the Court of Appeals reasoning in applying Steiner and their legal definition of that, when we look at the facts of this case, it's clear that these chickens are not pets. So the outcome there is, so we have Steiner that tells us we want to make sure we have a well-drafted restriction, and that same outcome applies to Schroeder, but also it's important to look at the specific facts. So while if we change the facts of Schroeder, and let's say maybe there were three chickens, plenty of people have three dogs that were cared for, just like allegedly the 60 chickens were. Maybe the outcome would have been different, and the Supreme Court would have said, yes, we agree that those three chickens are pets. But in this case, I think the sheer number of chickens that the Schroeders had is what did them in on not being pets. One last pet example for you. This one is not an HOA case, but it has a similar analysis. And this is Heron versus the town of Jamestown. In this case, the town of Jamestown had an ordinance that prohibited the keeping of non-commercial animals, such as fowl, chickens, turkeys, ducks, and geese, bees, and other small animals, and limited agricultural use animals. Limited agriculture does not permit livestock, such as horses, cows, llamas, sheep, swine, or the like. Now, the Heron family, they lived in the town of Jamestown and they decided they wanted to have a potbelly pig. That they started with just one potbelly pig. The pig lived in their house. It had a sleeping area in the primary bedroom closet. Imagine giving up your bedroom closet for your pig to live in. In the yard, there was a fence for the pigs to roam. The owners kept the pigs as pets. They provided veterinary care. There was no reported commercial use from these particular pigs. And they allegedly developed a familial bond with the pig. And as time went on, the amount of pigs that they had grew as well. Eventually having 10 potbelly pigs live in their house. And I'm told those potbelly pigs could get up to 100 pounds. So that's quite a bit of pig living with you. Now, here, the ordinance specifically lists swine as livestock that's prohibited. And we are using this case because it's an example of a well-drafted restriction, because while it carved out a certain exception to the rule for certain types of animals, it did say no livestock, and livestock included swine. Therefore, the Court of Appeals, when the town of Jamestown told the Herons they had to get rid of their pigs, and the Herons didn't want to, and they sued, the Court of Appeals said, no, these pigs are not pets. They're not prohibited. They are swine, which are prohibited by the town ordinance, and you've got to get rid of your pig. I think that's all I got on pets. It's pretty easy to run through. If there's any questions, happy to take them before we move on, but just some entertaining stories for y'all
I,
in actual cases out of North Carolina.
I'll say that it's silly, but so for normal pets, dogs, we get a lot of dog poop pictures in the mail. We will get dog neighbors complaining about dog waste. How do you recommend associations to manage those types of violations? If you can identify the animal, and maybe if you can't identify the animal, who it belongs to.
Well, to start, I would want y'all to have a restriction or a rule, a covenant in your restrictive covenants that addresses, if particularly for dog poop or animal waste, that owners that have pets must clean up after their dogs. Because that goes back to what we talked about at the beginning. Yeah, you can have your rules and regulations, but that's only going to apply to the common area unless you have a specific provision in your declaration that allows you to implement rules over the lots. So if you rely on your rules and regulations to say owners with pets must clean up after their pet, clean up waste, but primarily you're seeing it that the waste is on a neighbor's lot that's not being picked up while they're walking their dog. Well, the association then doesn't have authority there because those rules and regulations only apply to the common area in most cases. So if you put it in your declaration that owners must clean up after their dogs, then in theory that's going to apply to wherever the waste is left, on a neighbor's lot, on common area, wherever throughout the community. Now, when you want to have a specific provision, like maybe you have a pet section and then you have a subsection there that talks about cleaning up waste. So let's assume you have that provision in your declaration and you're looking to enforce. Like Ben pointed out, it's going to be important. Can you identify the dog and the owner of that dog? Because if you've got people that are leaving waste, but you can't identify who's not cleaning it up, then who are you going to enforce this after? So if you're able to implement it, I know apartment complexes, in my experience, sometimes will require pet owners to provide a DNA sample. So if there's waste being left around the apartments, you can test the waste and figure out whose dog it is that's not being cleaned up after. But that's really, if you're gonna try to go the route of fines and enforcing under your declaration, you're going to have to take some sort of step like that to identify it, because most of the time, if someone's not picking up after their dog, they, there's not someone around to see it. I think if there were other people around, someone might grab a poop bag and pick it up and feel the pressure of their neighbors. So from there, while enforcement may not be practical, there's other steps that we've seen community associations take, and particularly even if you can enforce it through a measure like a DNA testing, like I explained, unless this is a rampant issue, it might not be a practical way to enforce it. So for providing dog poop bag stations, things that make it easy for the homeowners to clean up waste, oftentimes is going to be a practical solution that just makes it easier on the homeowners. They don't have to go buy the dog bags themselves. They don't have to have a separate trash can just to dispose of the poop, etc. Um, while And that's a good way to provide for that happening, but not really a legal answer, because you can fine if you have a rule, but if you have no way to identify who did it, there's no real way to uh, enforce that rule.
Mhm.
Which it's not a perfect solution, but
Yeah.
we're not HOAs, you as board members aren't there overseeing and watching everything that everybody does. So you can't enforce something that you can't prove, is the moral of that story.
Right. So this question is interesting. Any issues or court cases with invisible fences being against sidewalks or the property line having setbacks? Sometimes if the invisible fence is too close, dogs could get in fights with little or no control by the owners.
That is an interesting question. That I do not believe that there's at least appellate court cases on that. Not to say that anyone's gone to a trial court. Just generally, when cases go to the trial court, we don't have the ability to find them as easily as the appellate cases. But thinking through that, the setback question is interesting because setbacks generally prohibit you from building a structure within certain areas on your lot. And these are privately owned lots. So unless there is a specific requirement for the setback in your declaration, there's no ability to regulate what someone does on their lots. And that outcome is going to come down to the interesting decision on, is building an invisible fence or installing that infrastructure likely under the ground. I admittedly am not an expert on how the invisible fences are put in, but because it's invisible, you can't see it. So there's some sort of technology there installed underground, I would assume, and whether that constitutes building in a setback. And I think my initial reaction there is because it is underground, the building setbacks are not going to apply the same as it might for a physical structure that is on top of the ground. Um, Now, it's an interesting scenario to work through, and if that is a concern in your community, you can certainly pursue an amendment or something that implement not or not or something an amendment to your declaration that contemplates invisible fences and requires an invisible fence to be installed a certain amount of feet back from the lot line, similar to a setback. But for invisible fences that are installed prior to the amendment, if you were to pursue an amendment to specifically address invisible fences, those invisible fences prior to the restriction would be grandfathered in and allowed to remain. Now, when it comes down to that, let's going through that analysis and determining, okay, maybe that setback doesn't apply. But you've got this invisible fence right up on the lot lane, and dogs can get at each other over that invisible fence. If that occurs, because ostensibly there's likely not a violation of the declaration, that is then a neighbor to neighbor matter where if the home, I mean, either way, if it happens, even if there's an association restriction, to the extent two individual dogs are causing issues with each other, you can always refer that back to the neighbors and say, hey, it's a problem with your neighbor. The association documents do not give us the authority to intervene on that.
Yeah. Okay, I'm going to ask two more questions and then we'll jump back into your FHA stuff and then I'll circle back to different questions. This next one may be, again, a neighbor to neighbor issue that the association docs may not address. But if one neighbor tethers their dog along the property line and the other dogs, while tethered, have access to a neighbor's yard, the dogs do damage to the yard, does the association have any authority to restrict the tethering?
Yeah, and it depends on if there's a rule. That and hopefully in your restrictive covenants for the reasons we've already discussed. If there's no covenant that prohibits tethering a dog in the front of the yard, then you're going to err on the side that the association doesn't have authority to prohibit it. Now, if when the dog goes onto another yard and creates damage, maybe they dig up the yard, they knock over a planter, damage the grass, whatever, that is potentially a trespass and potentially damage to personal property that is the neighbor is going to have recourse with their neighbor who owns the dog that caused the damage. But unless there's a restriction that prohibits tethering of the dogs, there's no way for the association to intervene. And to the extent there is a restriction that prohibits the tethering, the association can only intervene to tell neighbor one that they can no longer tether their dog. And if they're going to, they will be fined for the violation. And the association does not have any obligation or any ability to address the damage to a neighbor's property.
Okay. This next question probably will get into your FHA discussion, but is the association allowed to request any documentation of an emotional support animal or service animal as long as it does not reveal the HPI? So
So
it's
that,
homeowner personal information.
okay.
If so, signatures, profession are legit. For example, is a licensed clinical social worker sufficient? Documents can be purchased online as a way to get around pet fees that we have found. So that may transition to what you want to talk about with FHA. So
We are going to get into that in a minute. I'll give you a little sneak peek that's going to depend to an extent on the type of animal that is alleged to be an emotional support animal. In 2020, HUD, the Housing Authority, gave us a updated guidance on this exact question and made a distinction between ordinary animals and unique animals. And we will talk about that in a couple minutes. Going to move through this. Just one last thing on pets. This is best practices. This is some suggested language. I'm not going to read it for you. Y'all can skim through it right now. This is what my firm uses in our standard documents when we're drafting pet restrictions. That gives the association broad authority to regulate pets and prohibits certain types of pets as well in commercial uses. Of course, if you want to update your documents and are looking at pet issues, we are always happy to help there. So moving on to assistance animals, similar to pets, we're going to start with what is an assistance animal. An assistance animal is any animal that works, provides assistance, or performs tasks for the benefit of a person with a disability and or that provides therapeutic emotional support for individuals with disabilities. So from that definition, is an assistance animal a pet? No. So if all that discussion we just had about restrictive covenants and prohibiting pets and whatnot, that applies to just standard pets. It's just like me and my dog at home. He doesn't provide any services for me. He's just my pet. So he's a pet and the assistance animal rules don't apply to him. But let's say I had some sort of condition that required assistance and he provided service to me. He did a specific task, then he would transition from being considered a pet to an assistance animal, and the discussion we're about to have would apply to him, and the pet discussion we just had would not. What type of animal can be an assistance animal? Really, the answer to that is any animal. A dog, a cat, a chicken, goats, sugar gliders, alligators, flamingos, peacocks, turkeys, snakes, bees, etc. Any animal can be an assistance animal as long as they provide some form of assistance, which is such a broad description. Now, within our broad category of assistance animals, we have two types of assistance animals. You have your service animals and your emotional support animals. Service animals are going to be, next slide, there we go. And this is the exact Code of Federal Regulations definition for service animals. So I guess this is a good time to mention that, like I said, with the pets, we were going through a specific case law and applying legal principles in North Carolina, that there are similar scenarios in South Carolina. So we believe in a similar circumstance, the pet discussion would apply similarly in South Carolina. Now, what we're transitioning to here with our service animals and emotional support animals, this is federal law. So this applies to all states the same. For you South Carolina folks out there, this is going to apply to you just the same as North Carolina. Now, a service animal is any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. Other special animals, whether wild or domestic, trained or untrained, are not service animals for the purposes of definition. The work or task performed by a service animal must be directly related to the individual's disability. So that comes directly from the Code of Federal Regulations and tells us that a service animal can only be a dog. Any other type of animal is not a service animal. Now, a common response I get to that is, well, what about miniature horses? The Code of Federal Regulations talk about miniature horses, and while they are not a service animal by definition, we give a similar analysis to miniature horses to determine whether the rules for service animals apply to them as well. Again, they have to be individually trained and they have to provide a particular service. So some examples of that are seeing eye dogs, alert dogs. So if someone, for example, has diabetes and if their blood pressure gets low and they're prone to fainting, there are dogs out there that are trained to alert the owner to notice the types of reactions from the owners, changes of behavior that are common with low blood pressure, and that dog will alert the homeowner that their blood pressure is being low or that they might faint. Other examples are if someone's in a wheelchair and they have a dog or a miniature horse that pulls them, and then dogs that retrieve items for individuals such as medicine or the telephone. And then finally, dogs that help with balance for individuals with mobility disabilities. One important example is that crime prevention is not an example of a task performed by a service animal. So you cannot have a dog simply as a deterrent from someone else doing something to you and call that a service animal. The service animal must perform a specific task for you, such as those described. So in contrast to our service animals that can only be dogs, and then miniature horses are given a similar analysis but are not defined as service animals, we have emotional support animals. An emotional support animal can be any type of animal. That discussion that we had at the right before the service animals, dogs, cats, chickens, goats, sugar gliders, alligators, etc., that's going to apply to your emotional support animals. And a common one that we see here is homesteading with emotional support animals. So we've seen circumstances where a physician will prescribe homesteading to individuals to help them with emotional needs, to help calm them down, whether it's raising chickens and cultivating their eggs. Another common example of homesteading is with combat veterans or anyone else that suffers from PTSD. Homesteading with bees specifically is often prescribed to help as therapeutic for PTSD, something in the process of keeping the bees, cultivating the honey, etc., provides a benefit to them. So that's how your chickens, your goats, your bees, etc., are going to be considered emotional support animals. Maybe even alligators, preview to come. So this here is where the question that was posed right before we changed pace to our assistance animals is that's where this discussion comes in. So as you know, or you may or may not know, under the Fair Housing Act, individuals with assistance animals can request a reasonable accommodation. And what that means is they're going to request that the association is going to set aside a rule to accommodate their need for an emotional support or a service animal. For example, say you have a pool and the association has a rule, no pets are allowed at the pool. Well, someone needs an emotional support dog or a service dog, and they request a reasonable accommodation to allow for them to bring their dog with them to the pool. So in that case, a reasonable accommodation is you're going to set aside the rule and say, yes, the dog can come to the pool, but maybe not allow the dog to swim in the pool, and that the dog can hang out with you on the pool deck and be there to provide service for you or your emotional support. But unless there's a specific need for the dog to be in the pool, you don't necessarily need to set aside all of the rules, just the rules to allow someone to have the same access to the pool as anybody else. That's an important distinction when you're considering reasonable accommodations, and we could do a whole presentation on just reasonable accommodations. But the reasonable accommodation allows someone to have the same access as someone without the disability, not better access. So when it comes to that, oftentimes when you're evaluating the reasonable accommodations, there's the question, okay, what information are we going to request? How do we evaluate this? Do we just rubber stamp everything, or are we going to ask for some documentation on the need for that animal? And here we're looking at it in the context of the specific animal requested, not, and the question asked, I think, was geared more towards the condition that requires the need for the animal. But here in the HUD FHEO notice 2020-1, we're getting at the types of animals. So we'll talk about that first. For animals that are commonly kept in households, the reasonable accommodation should be granted because the requester has provided information confirming that there is a disability-related need for the animal. And HUD has told us that animals commonly kept in households are dogs, cats, small birds, rabbits, hamsters, gerbils, other rodents, fish, turtles, other small animals, or domesticated animals. So in a circumstance where a reasonable accommodation has been requested. They've provided the proper documentation, if applicable. There's a clear need for the reasonable accommodation. If it's one of those types of commonly kept in household animals that are commonly kept in households, you're going to say yes, no matter what. You don't have the ability to say, okay, why do you need that specific dog? You don't need someone to tell you that Fido performs this task. They just need to show that they need a reasonable accommodation and they're requesting it for a dog, so it should be approved. Now, in the context of unique animals, which are reptiles other than turtles, barnyard animals, monkeys, kangaroos, and other non-domesticated animals, the individual making the request for the reasonable accommodation has a substantial burden of demonstrating a disability-related therapeutic need for that specific animal or the specific type of animal. So an example there is if someone is requesting an emotional support kangaroo and a reasonable accommodation for an emotional support kangaroo, they're going to need to provide documentation from a healthcare professional supporting why that kangaroo, a kangaroo or that specific kangaroo, are necessary to provide the therapeutic, the disability-related therapeutic need. And if they do not provide that documentation from a healthcare professional, that would be reasonable grounds to deny the emotional support kangaroo or the reasonable accommodation for the emotional support kangaroo. Now, I don't have a slide on it, but I'll just talk briefly on kind of getting at what the previous question asker was asking as far as just what you can ask for when you are determining or evaluating a request for a reasonable accommodation. Now, there I'll start with there's a couple things to keep in mind. First, is the need for the reasonable accommodation clear and obvious? So, for example, if someone's in a wheelchair and they're requesting a reasonable accommodation to bring their assistants, their service dog with them on the common area, you're not going to be able to ask for additional support there because it's obvious that they need that dog. Or if a seeing eye dog, another example. Now, if someone is requesting a reasonable accommodation for their emotional support dog, maybe it's an alert dog for a condition that they have where they are prone to fainting, like describing earlier, and the dog's going to come up and nudge them and say, hey, you need to sit down, or your blood sugar's low, you need to go get a snack. That's not, you can't usually look at someone and tell that they've got a condition, an underlying condition like that. So it's reasonable to ask for some documentation there, and I'm hesitant because I know I think I would assume the basis of this is, okay, well, anyone can get on the internet and find someone that will rubber stamp any sort of emotional support animal for them. So ask if it falls under that category where it's not obvious, and you can generally ask for documentation. And I always recommend you consult your attorney before you ask for documentation. Even if it's falling under what I'm telling you right now, double check, make sure you go through your attorney, go through the process properly, because you don't want to get in an issue where you ask for something you're not allowed for. Help them guide you step by step through the process, because they're going to give you more specifics than I can in this type of format. So, and you ask for that documentation, and then you get something that you're suspicious about. Okay, maybe this actually isn't their provider. This isn't somebody that they've been seeing for a few years. This is someone that they just found on the internet. In that case, there are certain circumstances where you can question that. But again, I will caution you to consult with legal counsel in doing so. So it just, If you're getting to this stage anyways, my advice would be to have legal counsel involved and let them guide you through what level of scrutiny you're going to apply to medical records that you're requesting. Okay.
Okay, Hunter, we're starting to get some questions. So I don't
Yes.
know how many slides you have, but
From there, we've got examples and I've
okay.
given them. So I think questions might be better than these examples. I can roll through this quickly. Wally the Gator. You haven't heard of him, Google him. Emotional support alligator out of Pennsylvania. That's just an example. And then this capuchin monkey, another assistance animal that can go and get things for you. So maybe you got a quadriplegic who's in a wheelchair and they need help opening doors and whatnot. An example of what a capuchin monkey can do for you. They can go grab a water bottle out of the fridge, take the cap off, put a straw in it. Examples of types of emotional support animals. Yeah, so we can roll with
Okay,
questions.
excellent. So would we need to refer to the governing documents on how the pets, dogs, and cats are kept? For example, if a homeowner that has one or two dogs and leashes or ties them on their property, not in an enclosed area, for several hours at a time sporadically throughout the week, should the HOA enforce that?
So should you refer to your governing documents? Yes, it's always the answer. If you're asking, should you refer to your governing documents? And this, if the HOA is going to take unilateral action, potentially fine somebody for the tethered and leashed dogs on their property, you're going to want to make sure that there is a restriction that corresponds to the violation that you're pursuing. Now, some people may argue that that's a nuisance, and we can do a whole other presentation on nuisances. I might caution you for going the nuisance route because if your nuisance provision is too broad and it gets challenged, that Steiner case also had a nuisance aspect to it where the nuisance clause was ruled void for vagueness by the Court of Appeals. So because the homeowner association tried to say that those goats were nuisances, all of a sudden they go to court and they come out of court with no nuisance clause anymore. It's unenforceable. Now, what we see with dogs like that are tethered barking for several hours, I have seen ordinances and animal control ordinances that discuss that, and it may be appropriate for the association to call animal control if the specific town you're in has some sort of ordinance that addresses dogs barking, or refer the homeowners that are complaining to call animal control. And then that's a scenario where you're going to get local government involved. Animal control job is to respond to that, unlike parking issues where it's hit or miss on whether local government's actually going to come out and look at it. Animal control should come out on a complaint, and then no skin in the game for the association. Animal control is going to take care of it, and it makes your lives easier, and it gets the same outcome.
Yep, absolutely. And there's actually a question down below that says, how do you control barking dogs and howling at 2 a.m. or 4 a.m. outside?
You call
And
animal control.
yeah.
You call the police.
Now, you also mentioned the nuisance provision.
Yes.
You know, so you can tell, one thing that we've used in the past with nuisance provisions, if the police respond and they do cite the owner,
Mhm.
you have a government official saying that there's a problem, right? And so the more of those gives you more validation in enforcing a nuisance provision.
Absolutely, because your nuisance provisions by nature are subjective. So the board it's unlike whether you have a fence painted the wrong color. That is, okay, is the fence white? Yes or no? Easy to document that violation. A nuisance, well, once with something like barking, you can't just take a picture of barking. Maybe you can have an audio recording of it, but the more documentation from someone like the police, animal control, or whatnot that comes out and says, yes, there was an incident, the more of that you have, if you do go the fining route and instituting fines under your nuisance provision, if you get into the context where you're enforcing that and the homeowner pushes back and all of a sudden you're in front of a judge explaining why a nuisance occurred, that helps you in that circumstance. And gives the judge a reason to say, yes, a nuisance occurred and these fines were proper.
Okay, so an association has dogs under control or leash laws. Does someone claiming their dog is under voice control have the same merit in not complying with a leash law?
No. If you have a a provision of your restrictive covenants that says dogs must be on a leash at all times when off private property or unless on a lot in an enclosed uh, area, such as a fence, then anytime that they're walking the dog off their lot on the common area, along the sidewalks, on the street, wherever, they're required to have their dog on the leash. It doesn't matter the behavior of the dog. Same thing applies for local ordinances. I know here in Raleigh, we require dogs to be on leashes. Now we can talk for probably another 30 minutes about the association enforcing local laws and what you need to do that. But similar analysis applies there. If you have a restriction that requires dogs to be on the leash, doesn't matter how trained the dog is, they must be on a leash when off of the lot.
So, interesting question. If your CC&Rs don't speak to an aquarium and aquarium limitations, but it does restrict load calculations on floors, so this is a condominium, and a
Okay.
high rise
Okay.
to about 40 pounds per square foot. How does someone know if an aquarium, which may be very heavy, um, you know, overload a specific area, and is that an enforceable rule?
In that circumstance, you're likely going to want some form of outside opinion, expert opinion. However, whatever form you would use, go about on that pound per square foot in determining that for other circumstances outside of an aquarium. I'm going to be straight up with y'all. I have not encountered this myself, so I don't know from personal experience or past experience where to send you on that. But if you're going to try to apply that to an aquarium, I would want you to have an expert opinion. And because you're in a condominium, you likely have the ability to enter or potentially have the ability to enter the unit for reasonable inspections. And you're get an expert, get some sort of engineer or whatnot to do a calculation for you and determine whether there is that pound per square foot violation, and apply it evenly the same you would for any other type of personal property kept in the condominium.
Okay, back to the nuisance question. I know nuisances are, I think
Yeah.
we do have a webinar all about nuisances probably from a few years ago, but regarding my earlier question, which should be read in its entirety, I would add Article 7.7 on nuisances in our covenants prohibits causing unsightly and unkempt conditions on a lot, including things like obnoxious to the eye and anything done to cause an annoyance or nuisance to any person using any property within the community. No animal shall be maintained in the community whose activities or existence is in any way noxious, unsightly, unpleasant, or of any nature may diminish or destroy the enjoyment of the community by other owners. Do you think this language is specific enough? And I know the answer.
It depends.
Right.
Every law student's favorite answer, because our professors tell it to us a million times a week, and then we start practicing and we start telling it to our clients. It depends. So in that circumstance, this is where I was mentioning earlier that nuisance provisions are highly subjective. So what is noxious, offensive, unsightly to me might not be noxious, offensive, or unsightly to you. So when we do draft nuisance provisions, we like me and my law partners and we like to add sub bullets to that in there. So you've got like subsection one, section one, and then subsection A, B, C, D, etc., and say and provide specific examples, such as junk cars, debris, garbage, whatnot, and that adds to what unsightly is. Now, when it comes to an animal, sure, if you have a barking dog that barks for 4 or 5 hours at a time while their owners are away, good chance that's going to be obnoxious and that's going to be subjectively noxious. But the same circumstance where we would want best practices would be to report it to animal control, call the police, get some sort of reports out that confirm this is the conduct that's happening. Uh, would be the best way to go about that because you have something that is a little more objective to give you teeth to the enforcement that you're pursuing.
So regarding enforcement,
Mhm.
um, is it appropriate and or required for the board to send a written complaint from the association to an owner before it takes any sort of enforcement action?
If it's certainly reasonable to provide written notice of a potential violation beforehand. Now, your managers, I'm sure, have guided you through the process that prior to fining, you are required to provide written notice and to hold a hearing and provide the owner the opportunity to be heard. So you're going to provide at least one written notice prior to pursuing enforcement proceedings anyways, but if you want to send out some sort of warning ahead of time to say, hey, we think there may be a violation here, we're not saying 100% there is, I don't see a problem with that. It's certainly reasonable to give the owner a heads up and an opportunity to correct it. And then if they don't correct the action, then the next letter is a formal notice of violation that has a hearing date attached to it.
Yep, and I'll say the hearing requirement is specific to North Carolina. So
That is true. Thank
South
you.
Carolina would definitely have to follow your governing docs. I think the general recommendation for South Carolina is to still try and hold a hearing, but it's not necessarily required. So just to clarify.
Yeah.
Um, if cats are running free, does the association, how does the association enforce cats? When dogs are normally leashed, cats are not.
Yeah, it's a good question. If you know or reasonably know who that cat belongs to, and there's a leash requirement, an enclosure requirement, some sort of restrictive covenant that applies here, you send a notice to the owner or who you reasonably believe the cat is owned by. And if that individual doesn't own the cat, they're probably going to speak up and say, hey, that's not my cat. Um, in the circumstance where there's you do not know who the cat is and it's been around for a good amount of time, and I mean it is a business decision on whether you want to pursue something, because the recourse that I would think of is to call animal control, and then the board needs to determine whether that's a proportionate response to the cat. If the cat's just around and not causing harm to anybody and neighbors like seeing the cat around, maybe calling animal control is, you'd say, hey, a business decision, we're not going to do anything about this cat. But if it's a cat that's causing some sort of problems, it's approaching individuals and scratching them or attacking dogs, and it's a bold cat and it's coming up to dogs and attacking them, maybe that's where you say, okay, as a board, we're going to step in and potentially call animal control. However, in those situations, you are never affirmatively obligated to. You just have the ability to.
Okay. Well, Hunter, I know I said we'd have a hard stop at 5:30 and it is 5:30. Um, so I want to thank you for your time. Thank you, all of you that are still with us tonight. So lots of great questions and great content. Reminder, we do hold these the third Thursday of every month. So happy to have y'all attend. Our next one will be with Hunter's law partner, Amy Wooten, and Alan Trask, all about insurance. So we're going to get into the insurance subject, not by an insurance agent, so by two attorneys. So should be an interesting topic. So again, with Hunter, thank you very much.
Thank you for
And,
having
and
me, and
thank you all.
My direct contact information is on the screen again. If anyone needs it, feel free to reach out if I can be of assistance.
Okay. Well, thank you and good night.
Thank you.